I'm not. I've heard this is a quiet room, so I'll try to speak up. My name is Carrie Abrams, and I'm a professor at the law school, and I also work in the provost's office. And it is my distinct pleasure and honor to get to introduce Martha Fineman to all of you. I have been a fan of Professor Fineman's since about the first week that I was in law school. And I've gotten to attend some of her conferences over the years, but this is the first time I've got to spend several days with her. And it's been a delight for me, and I think also for the other faculty and students with whom she has so generously spent her time over the last several days. Professor Fineman is known for many things. She started the Feminism and Legal Theory project back in 1984 at the University of Wisconsin. It was the first project of its kind, and it revolutionized the way law professors think about jurisprudence and feminism. She is noted for her theory of dependency that she developed during the 1990s. She made the bold move of asking us to think about the parent-child relationship as more legally important than the husband-wife relationship because of the dependence of parent and child, and revolutionized the way that family law scholars think about the family. And more recently, she has moved into a new area of what she calls vulnerability. And her great insight here has been that vulnerability isn't a descriptor for a particular person or for a population, but a feature of the human condition. We are all vulnerable, we are born vulnerable, we have the potential to be dependent on someone else at any given time, and therefore we shouldn't think of vulnerability as a derogatory term, but as something that applies to all of us. And we should use that observation to rethink the way we think about things like welfare, family, and work. So it is my honor to get to introduce to you Professor Martha Alderson Fineman. Thank you so much.
Thank you for that lovely introduction, and also thank you to Allison and Claire for the hospitality. I've had a really wonderful time here and met some really exciting and interesting people. So I am going to talk about vulnerability, but I'd like to start off by telling you that I have been struggling with the meaning of intimacy as well as its relationship to vulnerability and social justice since I was asked to present a paper in this series. The term intimate or intimacy can be defined narrowly or broadly, subjectively or objectively. It can refer to a person, an action, a space or a place, a decision, a feeling, or a relationship. Webster's dictionary defines intimate as characterized by a very close association or familiarity, affording privacy and informality, or as very personal. Encarta states the word intimate conveys a close relationship or a quiet atmosphere, but can also mean detailed knowledge resulting from a close or long association or study. It notes that intimacy, or the act of being intimate, has been used since the 17th century to substitute for sexual intercourse. The law's approach to intimacy also reveals that it is susceptible to different interpretations or emphasis. And I'm going to talk about the law as a scholar, of course. A reference to intimacy may indicate something experienced by or through the body, something done to or by an individual, and here we have the sexuality-focused cases. It can also refer to a decision an individual makes about her body, and of course these are the reproductive cases. During the latter part of the 20th century, certain personal intimate acts were granted constitutional protection from state intervention or interference under the mantle of privacy and consistent with stated ideals of individual autonomy, liberty, and choice. Employing these concepts, the Supreme Court heard cases involving contraception, abortion, and sexuality, and curtailed the state's ability to use criminal law to impinge on or interfere with certain individual decisions. But law and the idea of intimacy has also been employed beyond individual contained actions or decisions to describe ongoing relationships, intense relationships between individuals. And those intimate relationships can be given discrete meaning, be recognized in law as having an existence that goes beyond the aggregate individual's intimate acts or choices. For example, intimate relationships such as marriage can be the basis for the imposition of legal consequences or responsibilities that are independent of individual consent, but are defined and enforced by law. So the state's interest in marriage is expressed in regulations that control entry and exit from that intimate relationship. On one level, marriage, once created, has been considered a foundational relationship in a designated private sphere. The principle of privacy operates then to keep the state from interfering with the marital couple's interactions or relationships. But marriage has also been assigned important public or societal roles in ordering sexuality and reproduction. And those functions are reflected and reinforced in law and through heavily subsidized policies and initiatives that are designed to support and encourage marital families to act in certain ways. These laws and policies reflect state or public expectations for marriage and for the actions or activities of the marital partners. They are evidence of the active role of the state in defining the meaning of marriage. We could think of marriage, and I think of it, as a regulated intimacy. And the laws and policies that constitute the marital family are not given definition by an appreciation for individual autonomy, liberty, and choice. Rather, family law, addressing marriage and divorce, reflects an ethic of collective and mutual responsibility, which recognizes the intensity of the emotions of mutual commitment, dependence, trust, reliance, sharing, and caring that ideally exist in ongoing marital relationships. These are the norms that shape the expectations for marriage for both individuals and for society. And those norms have resisted revision, persisted even when the laws and policy have changed and the legal institution of marriage moved from a common law, hierarchical, gender-based, lifelong institution to its more flexible, egalitarian arrangement that we see today, reflecting ideas of partnership. The new rules still reflected collective and mutual responsibilities along with expectations of commitment, dependence, trust, reliance, sharing, caring, and so on. Now, in this slide, what we see, or what I want to see in this slide, is separating the legal approach to intimacy into individual versus relational branches. It leads us to reflect on the different position of the state in regard to each branch. And it's this separation of individual from relational aspects of intimacy that allows me to bring it into the vulnerability analysis. In vulnerability terms, individual intimacy celebrates an autonomous, independent, liberal legal subject. It rejects the whole idea of state intervention and state control. It is an alienated legal subject. While relational intimacy recognizes the reality of vulnerability on both an individual and an institutional level. Vulnerable individuals are joined together in an intimate, vulnerable relationship that is dependent on social subsidy and support and state intervention. The vulnerability approach generally begins with a consideration of two basic questions. First, what does it mean to be human? Is there an inherent or universally shared characteristic, situation, or circumstances comprising the human condition? So that's the first question. This is a foundational legal or political question. It's how we understand the political and legal subject. Second, given our answer to this first question, what should be the allocation of responsibility for individual and societal well-being across the individual, the state, and institutions? And the second question is a question of justice. It explores the creation and the terms of the social contract. My answer to the first question is that human beings are embodied beings, inherently vulnerable and susceptible to change, both positive and negative, in that embodiment. As embodied beings, we inevitably seek intimacy with others. We have a need for love, sex, but also for care and nurture. Second, and partly in response to our embodiment, we are also inescapably embedded in social institutions and relationships that are structured through society, in society both through law and culture. We need and desire institutions that provide for or facilitate structured, predictable, and stable relationships. In response to vulnerability, we join together in families, in communities, we create institutions, whether those institutions are subsequently labeled public or private, intimate or impersonal. Vulnerability leads us to devise political and corporate entities, develop and empower the nation state, as well as create international organizations. At the same time, considering our vulnerability forces us to acknowledge the inherent impermanence of the human condition in both its physical or biological, its embodied, and also its social or embedded manifestations. So, having resolved the first issue, what it means to be human, to at least my satisfaction, answering the second question about the implications of this for the responsibility has been my ongoing project within the Vulnerability in the Human Condition Initiative. And I started that project back in 2007 at Emory, and it's still going strong. And at Emory, we are developing vulnerability as the basis for a political legal theory articulating social or state responsibility for addressing widespread and growing inequality. It is a social justice project. The vulnerability project, our approach, is not based on an ideal of individual rights or human rights, however, but on a social contractarian assessment of human needs and a corresponding claim for state responsibility. A vulnerability analysis does not answer all the questions about which policies to pursue, but it operates as a heuristic that opens up sets of questions revealing the various complexities that should be part of any political judgment and emphasizing the political or social concepts by which that judgment should be measured. Okay, why is it needed? So it's fine. Why is it needed? So this is going a little bit into the origins of the Vulnerability Project. In earlier work, I had used the concepts associated with the so-called ethic of care to critique the prevalent fixation on independence and personal responsibility. There were two forms of dependency with which I was concerned at that time: biological or developmental dependency, the situation where one is dependent on the care of others. I labeled this inevitable dependency. It is universally experienced. We are all dependent on others for care as infants and children, and many of us become dependent on the care of others as we age, become ill, or experience other variations in embodiment. The second form of dependency was the one that held the most interest for me, however. It is not a universal form of dependency, as I was then thinking of it at that time. Rather, it was socially constructed or determined. I would label this derivative dependency to capture the very simple but often ignored reality that caretakers, those who care for inevitable dependence, are themselves dependent on resources in order to do that care work effectively and successfully. I critiqued the way in which the provision of these resources for caretaking were deemed to be primarily the responsibility of a designated private family, concluding that the family as an institution was the mechanism whereby we privatized dependency and care work in the United States. And I noted that within the family, this care work was typically relegated to women who served the gendered social roles of mother, wife, and daughter, and so forth. I argued this was an injustice. It was unfair that caretakers had to shoulder the burdens and risks associated with raising the next generation and or attending to those who needed the assistance of others in order to be able to care for themselves. This caretaking was socially beneficial and productive work, and it should be recognized and accommodated, not only with economic recognition, but also through institutional arrangements that made it easy to both caretake and participate in other activities. I argued that we needed to reallocate the responsibility and costs for care more broadly, include the state and its institutions to collectivize the burdens of dependency. Now, I thought this critique was pretty strong, and in fact it was well received by some. but others were able to nimbly force it into their dominant individualistic, privatized modes of legal and political concepts of responsibility. This is, of course, the same with the contract and the idealization of individual consent and freedom. Inevitable dependency, particularly in the childhood, was considered outside of traditional social contract concern. Capacity is required for contract, and children are lacking in that regard. This, of course, is not considered a problem in liberal theory, since we are all children at one point, and eventually we become adults. So no one is denied anything, at least permanently. Inevitable dependency can therefore be dismissed as episodic and temporary in nature, and already adequately addressed through social institutions. And claims of state responsibility for derivative dependency were also easily dispatched within this liberal paradigm. Those who choose to undertake care work had no right to demand that the rest of us subsidize that choice. Here again, the rhetoric of choice and consent. And as to a justice claim attached to derivative dependency, why should your preference for a child be entitled to any more regard than my choice to buy a Porsche or take time off to write poetry? These are all individual choices for which one should assume individual personal responsibility. The liberal legal subject who occupied, this is the Brooks Brothers version of the individual legal subject. The liberal legal subject who occupied the center of legal, political, and economic theory, and still does to a large extent, is both the maker and beneficiary of the social contract. He is defined through the ideologies of individual liberty and choice. This legal subject, if and when he seeks intimacy, considers it a private matter incidental to his right to liberty and life and the pursuit of happiness. So this is what I got. Discouraged but not defeated, I returned to my earlier work and thinking things through, and realized that beyond or before dependency, there was an even more foundational and universal aspect to the human condition. This is the inherent, inescapable, constant reality of human vulnerability. In the dependency work, I had posed the question of what it means to be human too late, and posed it wrongly. My analysis at that time presupposed two separate existing legal subjectivities, the caretaker, who was the adult subject, and the dependent child, and minimized the significance of the intimate relationship between those two separate individuals. The caretaker, who was an adult, was presumed capable of functioning as a fully autonomous agent, therefore relegated to the realm of choice. This full legal subject was in relationship and caring for an inferior legal subject, the inevitable dependent, who, because they were dependent, was deemed lacking in capacity, therefore not a fully realized legal subject, and the inevitable dependent fell outside of the ambit of state responsibility that attached to the full legal subjectivity. At this point, I realized that what I needed and what I wanted was a concept that recognized full legal and political subjectivity for both caretaker and dependent, and also included a recognition of their relationship of care and dependency, a relationship that was natural, productive, and worthy, if not entitled to, state support and subsidy. Key concepts in understanding vulnerability. Often narrowly understood as merely an openness to physical or emotional harm, vulnerability should be recognized as the primal human condition, universal, constant, and continuous over the life course. However, while human vulnerability is universal, individual experience is particularized. Vulnerability has two dimensions of particularity or difference. Humans are embodied beings and are also inevitably embedded in social relationships and institutions. So the embodied is the upper one. This is the man without his Brooks Brothers suit over the life course. Unlike the abstracted adult liberal subject, the concept of the vulnerable subject begins with this notion of embodiment. The vulnerable subject encompasses individual differences and variations. Importantly, as embodied beings, the vulnerable subject is a doubly dynamic concept. This level variation we see here is a variation, a horizontal variation among individuals. But the vulnerable subject reflects, in the first instance, variations in embodiment among or between individuals, but also reveals the variations in embodiment that transpire for any one individual over their lifetime. Variations reflecting that individuals have a life course and that change in our embodiment over time is inevitable and natural. And this is the variation, vertical dimensions of embodiment. Understanding both types of variation inherent in the human embodiment should have implications for defining the ideal relationship between the state and the individual legal subject, and for drafting and interpreting the terms of a realistic and just social contract. In fact, the first form of variation, the horizontal variations, can we go back to the slide? Already has responses in law. Anti-discrimination and equal treatment principles have made, I didn't do it. Have made,
I touched nothing. I touched nothing.
it's probably not. Speaking of vulnerability, just vulnerability.
I touched nothing.
Is anything happening?
No? Oh, fine. It's just we have to wait for it to warm. So I
15 seconds.
how it's hashtag to the rest of your slides.
There's one of them that's a lot of writing.
I know.
It'll come back. It's just, sometimes I think it's programmed to like shut off if somebody doesn't shut it beforehand. It's weird.
Oh, there it goes, okay.
It should be there.
It should be.
I was doing it.
Oh, there it is, okay.
I was doing a talking of Great Britain on vulnerability, and in the middle of it, the janitorial staff came in and said, "Oh, we're going to do it better."
So my apologies.
You have to be prepared for everything. All right, back to slide 8. The first form of variation, these horizontal differences among individuals, has already altered our perception of state responsibility. So anti-discrimination and equal treatment principles have made progress in regard to inclusion for individuals located across a variety of different categories of difference based on variations in race, gender, sexuality, ability, and so forth. But at the same time, down to 9, sorry. But the same attention to and consideration of variation has not happened when it comes to vertical differences in embodiment, those differences that inevitably and naturally occur for every individual over the course of a human lifetime. So full legal subjectivity may now be afforded to different races, genders, sexualities, and so on, but the legal subject remains imagined primarily as a static, unchanging being, an adult and fully functioning. Children, and some elderly and others, still are defined as discrete groups and given separate and qualified legal identities. Significantly, what is obscured by the static vision of the legal subject is the constancy and inevitability of dependency. Bodily dependency, dependency on care, again, is the inevitable realization or manifestation of our vulnerability, and the vulnerable subject will also, although not always, be dependent. I already addressed this form of dependency on care relationships inherent in some developmental and social stages, what I labeled inevitable dependency, and I think that the earlier work did a fairly good job of exploring that. But my earlier discussion of the second form of dependency, this derivative dependency concept, was not sufficiently developed in my earlier work, and I have been working on it in the context of vulnerability. In formulating the idea of derivative dependency, I had been narrowly and wrongly focused on the individual, the caretaker, as the adult legal subject. I do not treat caretaking as one aspect of a developmental stage in the life course of an embodied vulnerable subject, a stage marked by the emotional and/or reproductive aspects of embodiment and the impulse for the creation of intimate relationships. So we could call, and many of us do, caretaking an individual choice, but it is a choice shaped and limited by both individual embodiment and social circumstances and expectations. I realized that the appreciation of the full legal subjectivity of the vulnerable subject meant that caretaking should be seen, along with other options and opportunities, as a natural, inevitable expression of the need for intimacy and families that all humans share. Undertaking caretaking was one way for the vulnerable subject to respond to the evolving need for physical and emotional connection inherent over the life course. And caretaking created a relationship with societal expectations and responsibilities that transcended individual intent and mandated state interest and involvement. So caretaking was decidedly not to be seen as creating a separate extra-legal category that absolved the responsibility of the state for either inevitable or derivative dependency. Folding the caretaking relationship along with inevitable dependency into the life experience of the vulnerable subject did not lessen the significance of my insights about the derivative dependency and the reliance on resources and institutions associated with care work. So I still kept that realization of the need for support, for resources in order to undertake care. In fact, it broadened it as I realized that derivative dependency is a characteristic of most aspects of life. Human beings are inevitably and inescapably caught up in social relationships and institutions throughout our life course. The dependence of the caretaker on institutions and relationships is exemplary, not only derivative. It reflects the necessity of relationships and structures or institutions upon which we can rely in all aspects of life. Further, given our dependence on these institutions and their social significance, we must interrogate the role and functioning of all institutions in society, including those financial and other institutions that are classified as private, and for that reason not typically thought to have structural or primary responsibility for dependencies. But these institutions are key in regard to understanding the social dimensions of human vulnerability and the ways in which we are embedded in and dependent upon webs of relationships and institutional arrangements throughout life. This last assertion brings me to the concept of resilience. And resilience is centrally important in a vulnerability analysis. Properly understanding vulnerability as arising from embodiment and located within social contexts should make it clear that there is no position of invulnerability. There is no invulnerability, but there is resilience. Resilience is found in the material, cultural, social, and existential resources that allow us to respond to vulnerability. This is the only real textual slides. I apologize. Resilience is measured by the individual's ability to survive or recover from harm or setbacks that inevitably occur over the life course. Resilience also has positive connotations, so it's not just in response to negative things. Resilient individuals can form relationships, undertake transactions, take advantage of opportunities, or take risks in life, confident that if they fail the challenge or meet unexpected obstacles, they are likely to have the means and ability to recover. So resilience is very positive. Resilience allows us to respond to life, to not only survive, but to thrive within the circumstances in which we find ourselves. So my argument to neoliberal advocates of cuts in social welfare policies would be, it should be apparent that a certain measure of resilience is essential before there can be any semblance of agency or autonomy, and in reference to personal responsibility. And significantly, human beings are not born resilient. Rather, resilience is produced over time and within social structures and under societal conditions over which individuals have little or no control. And while it is evidence that resilience is not distributed equally, if we understand full state responsibility as existing over the life course of a vulnerable subject, we need to look at the institutional as well as the individual responsibility for deficits and disadvantage. While sometimes a lack of resilience can be deemed an individual failing, often it is a function of unequal access to certain societal structures and/or unequal allocation of privilege and power within those structures. So those who fail should not be segregated according to some characteristic or another and separated from the rest of us, labeled and stigmatized as vulnerable populations, as though they are differently or particularly vulnerable. Rather, they should be distinguished from their better positioned but equally vulnerable subjects by the fact that they lack sufficient resources and resilience to address their vulnerability. The problem is a lack of resources, not a lack in the individual. A problem of inadequate institutions, not inadequate individuals. And often this deficit in resources reflects an institutional or a societal failing as much or more than it does an individual one. The fact that a vulnerability analysis brings the life course into focus is important when it comes to this concept of resilience. No resilience-conferring institutions can operate both simultaneously and sequentially in society. They are sequential is significant, where a failure to successfully capture resources of resilience in one stage can fundamentally affect the ability to succeed in another. So an inadequate education, for example, will impair the ability of an individual to secure employment and accumulate material goods, which will also affect things further down the lifeline, like health, family formation, and prospects in old age. Movement into a new phase depends on successful accomplishment of the task set in the earlier stage, and it may be difficult to recover if that doesn't happen. The fact that institutions operate simultaneously is also significant when we think about resilience. Resilience gained through one institutional relational arrangement can offset or mitigate disadvantages in others and vice versa. So a strong family, for example, can sometimes compensate for a weak education. A violent or abusive family, on the other hand, will undermine the advantages of a strong education. Final point, and this is the important one, resilience should be tied to a well-developed notion of state responsibility. So if you look at this list, it's only a partial, keep adding things to it. It would include a variety of different institutions, those that are labeled both public and private, the family, the corporation, the banking or finance system, and so forth and so on. And these are the institutions through which resilience and resources are produced. Many of these resilience-conferring institutions are perceived to be separate from and independent of the state in contemporary political rhetoric. This is